Now, to help us sort this all out, we're happy to welcome back attorney David Weinstein with Hinshaw Culbertson in Coral Gables, and he also served as an assistant U.S. attorney for the Southern District of Florida for more than a decade. David, thank you for being here.
You're welcome. I didn't expect to be back so quick, but a lot happened today.
So much.
We'd like to have you. Okay, so all of this has been unfolding. Yesterday we saw a summary of the conversation between the leader of Ukraine and President Trump. Today we saw the whistleblower complaint, and then later the New York Times revealed some details about who this whistleblower might be. This is all unfolding very rapidly. What do you think has been the most damaging so far?
I think what's been most damaging so far, we talked about it yesterday a lot. Where's the quid pro quo? Why do we think that there was some sort of exchange for information? That's not necessary for an impeachment proceeding, but certainly when you view what happened, it helps to support the activity. Well, we saw that in the whistleblower's complaint. The last paragraph talked about a communication from the president directed to withhold the aid to the Ukraine. Now, whether that was a written document, whether it was an oral command to somebody, that's the quid pro quo that everybody was looking for. It's the one that's most commonly recognized. Again, not absolutely required to prove a high crime or misdemeanor, but everybody expected to see that somewhere, and now we've seen it.
So you do see a quid pro quo in that complaint?
Absolutely. If you're going to read the complaint, take a look at the last page and look at the final paragraph. It says it right there that he became aware, the whistleblower, of a directive from the White House, both prior to and after that conversation on July 25th, that said we need to hold back on the aid to the Ukraine.
So the president's personal lawyer, Rudy Giuliani, and we just heard Lindsey Graham say the same thing, that this is all just hearsay, that this whistleblower didn't actually just heard all of this information from other sources, and therefore it won't stand in the court of law. Is that true?
Well, if that's all they had, if we were going to march into the courtroom and that was going to be the only way to prove this case, none of that was going to come in because it is all hearsay. He doesn't have firsthand knowledge. But this is the investigation. He's providing the names and the details. They're going to use that information to interview those people, to track down reports, to get firsthand knowledge. That's what will be used to submit to the Congress to determine whether there are going to be articles of impeachment, and then ultimately to the Senate for the trial.
And now the whistleblower, he or she, whoever it is, it's somebody within the government who is following the proper channels. And these are very specific channels. Just go through that real quickly. First, he went to the Office of Inspector General, correct?
Right. He saw something, heard something, obtained information that he believed was in violation of both national security as well as the intelligence community, and believed it was an act that shouldn't have been undertaken by the president. So he went and did what he was supposed to do. The rules say you then have to report that to the Inspector General, and that it is an urgent matter, and that the Inspector General should then take that report and deliver it to Congress, because this is something that's important for them to look at. So the Inspector General took the information in the report, submitted it to the Office of Legal Counsel because there was a question of whether or not this was an urgent matter. Office of Legal Counsel looked at it and said, well, no, not an urgent matter. It doesn't have to go to Congress. It can be delayed a little bit longer. So the Inspector General then sat on it. It was somehow leaked out. Congress now said, where is it? And then today we finally got a copy of the report.
It also went to the Attorney General's office, no?
Well, it did. Through Office of Legal Counsel, it then goes up through Department of Justice to the Attorney General. They performed an analysis on whether or not this was an urgent matter that should go to Congress, and also a side analysis of whether there was a criminal act that was committed.
Really quickly, David, the recording that we heard that the LA Times got its hands on, is that obstruction of justice or witness tampering?
Let's begin with who it was directed at. What was the statement made towards? Did it intend to influence the testimony of an individual? If we're going to evaluate it for that, and we're going to believe that the statement that was made by the president about if we find these people and they're spies, that we should do what we do with all spies, which is to execute them, then that is getting very close to the line of trying to obstruct that witness's testimony in what could be a proceeding.
Something that we've seen in the past. Okay, thank you very much, David Weinstein, for joining us.
You're welcome.